Washington State Representative Matt Shea has publicly described himself as a, quote, constitutional, unquote, attorney. Shea is also the chairman of the Coalition of Western States, and his interpretation of the Constitution is the same as that coalition's, quote, legal advisor, unquote, Krisanne Hall. Like Shea, Hall uses the term, quote, constitutional attorney, unquote, in her bio. However, their use of the powerful word constitutional is only used to give legitimacy to their flim-flam. The last time I checked, on October 18, 2016, the Washington State Bar Association described Representative Matt G. Shea's law practice areas as, quote, personal injury, unquote. This is Shea in May of 2014 after he was involved in taking up arms against the lawful government of the United States.
Let me ask you about your trip to Nevada, and how did you manage to learn from that, and how did you help the situation by being there?
Well, in Nevada, let me back up. We had a phone conference on a Wednesday night between myself, Sheriff Richard Mack, and Stuart Rhodes of Oath Keepers, and we came to the conclusion, based on the real-time intelligence we were getting from the ground there, that this situation was escalating and likely was going to turn into another Waco or another Ruby Ridge. And so we decided amongst ourselves that it would behoove us to head down there to prevent that from happening, but at the same time take it as an opportunity to educate the American people on what was really going on, and why the Bundys were right to stand against the federal government. And so we went down there to Nevada, and for your listeners, as I'm a constitutional attorney, I'm admitted to practice in the Ninth Circuit Court of Appeals, so I'm not talking out of school here.
I guess Shea liked the ring of, quote, constitutional attorney, unquote, because he again publicly used this deception in describing himself on March 31st, 2015, in support of Nevada Assemblywoman Michelle Fiore's lands bill, Assembly Bill 408. Assemblywoman Fiore is also the Nevada coordinator for the Coalition of Western States. The following can be found in the transcript of the Nevada Assembly Committee on Natural Resources, Agriculture, and Mining of March 31st, 2015, pages 10 to 11. Assemblywoman Michelle Fiore states, quote, I would like Representative Matt Shea from Washington State, who is an attorney, to speak now on the constitutionality of this bill, unquote. Matt Shea, State Representative, 4th Legislative District, Spokane Valley, Washington, states, quote, I am the co-founder of the Coalition of Western States, an informal group of 30 state legislators from 6 Western states dedicated to protecting the property rights of citizens in the West. I am also a constitutional attorney by profession, and I have been asked to comment briefly on Assembly Bill 408. I applaud the work you are doing in Nevada to reclaim what was intended to be and is, as a matter of right, Nevada's state land. I want to brief 3 main points today. First, the federal government has failed to live up to its constitutional and historically established obligations. Specifically, Assembly Bill 408 would reaffirm and enforce United States Constitution, Article 1, Section 8, Clause 17. This very clearly and unequivocally states that Congress has the authority over all places purchased by the consent of the legislator of the state in which the same shall be for the erection of forts, magazines, arsenals, stockyards, and other needful buildings. It is very clear that vast swaths of land clearly fall outside the plain language of that provision. Unquote. It seems to me that was a very heavy lift for Shea, an attorney whose law practice area is that of personal injury. The legislation as presented to that committee was deemed unconstitutional by the State of Nevada Legislative Council Bureau. A heavily edited version of Fior's bill went to a vote in the Nevada Assembly on April 21st, 2015, and was killed by a vote of 34-8. During the fall and winter of 2015-2016, the Coalition of Western States was very active in inciting civil unrest in Harney County, Oregon, with their constitutional flim-flam. In fact, Krisanne, the so-called legal advisor for the Coalition of Western States, spent 2 days in Burns, Oregon, during the armed occupation, preaching their constitutional flim-flam. Recently, on an episode of Oregon Public Broadcasting's podcast, This Land is Our Land, they took a look at how the Coalition's Krisanne perverts the Constitution.
So, Conrad, we have another listener question. It's about the Constitution, and I want to bring in OPB reporter Amanda Peacher for this because she spent so much time at the Malheur Refuge listening to the so-called patriots talk about the Constitution. Hi, Amanda.
Hello, Amelia and Conrad.
So let's hear that tape from the listener, and then you and Conrad can tell us a little more.
Hi, OPB. Will you have an investigation or information on the particular constitutional beliefs of the occupiers? It seems much of the event can be traced to an interpretation of the Constitution they carried in their pockets. Thank you.
Thanks, Matt. We thought that was a great idea. The pocket constitution that you're thinking of is called the C.O.W.S Constitution. And there's a reason why it's handed out like candy at fairs and parades these days. We'll talk more about the C.O.W.S Constitution in just a little bit.
But first, let's talk about the occupiers' specific interpretation of the Constitution. There are 2 clauses of the Constitution that are important to understand here: the Enclave Clause and the Property Clause.
And here we're going to get a little law schooly, so stick with us.
We promise it's important.
First, let's talk about the Property Clause. For you Constitution buffs, that's Article 4, Section 3, Clause 2.
The Property Clause gives Congress the power to make all needful rules and regulations related to territory or property belonging to the United States. Basically, this is the clause that most people point to when they say the federal government has the right to own and manage lands.
But the occupiers point to another part of the Constitution, the Enclave Clause, to say that the federal government does not have that right.
If you want to follow along in your own pocket constitution, the Enclave Clause is Article 1, Section 8, Clause 17.
And it was quoted over and over and over again by the occupiers. Here, for example, is defendant Jason Patrick reading the Enclave Clause to me from his very tattered pocket constitution back in January.
To exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may, by secession of
And it goes on with specifics from there.
Basically, the Enclave Clause is 1787 speak about the District of Columbia. The occupiers quote the clause to argue the federal government can't own land outside of Washington, D.C., unless it's to build, say, a fort, in which case they'd go through state lawmakers to buy land for that fort.
So essentially, what we have is the Property Clause pitted against the occupiers' interpretation of the Enclave Clause. We checked in with Professor Michael Blum from Lewis and Clark Law School about these 2 clauses, and he said it's pretty clear how they interact.
They both exist in the Constitution, and the Supreme Court has said that the Enclave Clause doesn't limit the Property Clause.
So, in other words, Blum says, the Enclave Clause's mention of those 10 square miles of the District of Columbia doesn't mean that the federal government can't own land beyond that, based on the interpretation of the Property Clause.
And one of the cases that settled this matter, not surprisingly, started in the West. It happened in Utah about 100 years ago.
Well, the case I'm thinking about was a case called Utah Power and Light v. United States. The utility in that case said that they weren't subject to regulation by the Forest Service on forest reserve land because that land had not been purchased with the consent of the state, and the Supreme Court rejected that argument. That's the same argument that the people carrying around the Constitution in their pockets are making.
And Blum says that the Enclave Clause has never been interpreted by the courts in the way that the occupiers read it. But that doesn't change the fact that the occupiers' interpretation is spreading.
The federal government has no authority to own any land outside Article 1, Section 8, Clause 17.
That's Krisanne Hall in a YouTube video from January. She's a former prosecutor from Florida who now travels the country giving talks about the Constitution. You hear the occupiers and others in the Patriot movement referencing her a lot.
And her talks are popular. She's been to Oregon a few times since the occupation, and she always draws a crowd. One of her arguments is that the property clause is only meant to refer to territories.
Let's be very clear about this territories thing. Go read the Constitution. Territory is capitalized. This is a proper noun with a specific meaning, and the federal government owns no territory within the continental U.S.
But there's a very clear problem with what Hall's saying. The Constitution is full of capitalizations of nouns that we wouldn't necessarily capitalize today. And there's not necessarily a reason for it.
They were all about the uppercase in the 18th century. Words like election and profit and money are all capitalized in the Constitution. But Hall seems to be successful because she's seen as an authority figure. She has a legal background and is convincing a lot of people.
But to Blum and to most mainstream legal scholars, the legal arguments from the occupiers are just so outside the norm, they don't take them seriously.
But at the same time, there's a pretty strong movement afoot to sort of take back the Constitution that's gaining momentum across the American West. In one sense, it's tied to this larger frustration with the federal government. If you're someone who wants to see federal lands be turned over to local control, then the occupiers' interpretation of the Constitution might resonate.
Right. It's like confirmation bias. People are more willing to believe information that supports their point of view.
But at the end of the day, Blum says these constitutional arguments around the Enclave Clause have no chance of going anywhere in the court system. This debate is done and done.
They've set themselves up as judges because they're not paying any attention to the judges who've looked at this and have, over the centuries, interpreted it. So I guess the one lesson would be, from the occupier's perspective, every individual has final and authoritative interpretations of the Constitution. To me, that's complete chaos. Individuals should interpret the Constitution, but the final word comes from the courts. And the final word has been very consistent concerning the ownership and control of federal lands in this country for a long, long time, longer than anybody has been alive.
So we probably won't see this argument going anywhere in the legal system, but on the political landscape, that's another matter. Some of the same groups pushing this interpretation of the Constitution are also working on state bills to try and get federal lands turned over to states or counties. So this interpretation of the Constitution is definitely connected to the broader federal lands transfer movement.
All right, moving on.
3 of the many podcast sites where you can subscribe to This Land is Our Land are iTunes, Soundcloud, and NPR One. All of the episodes are well produced and informative. Washington State Representative Matt Shea, self-described, quote, constitutional attorney, unquote, and the rest of the members of the Coalition of Western States dishonor and do a disservice to their great country by knowingly selling their constitutional flim-flam as gospel. Buyer beware.